Worried when I crossed the Michigan line. A cop from Steuben County waiting on I-69. A headlamp went out while he pulled me over. Charged me with possession after I rolled down the window.
Now that's skunk.
Indians a trick when it comes to weed. It's like who doesn't smoke or use gummies? Your grandpa, your brother, your rich friend from school? Hell, throw in the whole courthouse and my attorney too. It's time those assholes change these stupid laws. It ain't worth the paper for a probable cause. Sitting on a bar stool in my usual place, this guy next to me said he was looking for some cocaine. Hell, I just sold him an 8-ball with a little piece off for me. But my buyer was a cop? Should've known he was a creep. So I'm a dealer, right? You gotta be kidding. It's a rich man's drug. I just take it because I'm injured. 8 years in Westville with a monkey on my back. There's more drugs in here than you can shake a shank at. One dirty drug test, man, this system's flawed. Undercover screwed me in my probable cause. Street crimes never did me no favors. I'm hooked on Fetty. I'm a junkie, not a felon. Told that son of a bitch on the way to lockup. I can't seem to shake it. I need help, not mocking. What do you want from someone who's been through the system? Drugs all through the house before mom and dad went to prison. Throw me in jail and give me a fine? Someday I'll be dead and away from your kind. Now I'm at the courthouse in front of a judge. Can't say my public defender cares for me much. Crimes are committed on both sides of the law. God help me now with this probable cause. C-shift never gets old. Anything can happen when you're out on patrol. You think I'm just eating donuts, man? Give me a break. Nothing on this job is a piece of cake. Lights and sirens activated. This knucklehead wants to chase. Baby mama at the scene just spit in my face. Wife's worried that someday I won't be pulling up at all. You'll read about my killer in a probable cause. Man. She went through my phone and she seen my text. I told her forget it. It was just my ex. She took a swing and knocked me flat. Man, I went wild and hit her back. Judge slapped me with a no contact order. Now she's got the kids and she's staying with her mother. So she started it all and I have to take the fall. You can read my whole story in the probable cause. When I was young, caught a case for dealing and did my time. Yeah, I got a record, but I was doing fine. Running my own business on the southeast side. Yeah, I got a gun. I kept it on hand. Told the cop my reason, thought he'd understand. In this neighborhood, you need some protection. Attorney thought I could get just community corrections, but the judge decided to send me to prison. Can't get ahead no matter how hard I try. Read the probable cause, it'll make you cry.
Whispers and rumors that don't get reported. Stories I write that are often distorted. Got my notebook and pen, and I'm ready to listen. Tell me the truth, I'll consider your position. I've seen killers with eyes so cold and dead, and others go to prison because of what someone said, rotting away for the rest of their lives, leaving a hole here on the outside. Things are sad here on earth, and it's no wonder why, when you consider the sociopaths who remain in charge. It's me who sees the system for all its flaws, and I usually start with the probable cause. My right hand is reading the probable cause. Welcome to the Probable Cause podcast. We cover Allen County, Indiana, and the northeastern Indiana region of 11 counties, and it borders on Michigan and Ohio. I'm Jamie Duffy, your podcast host, and with me is co-host Michael McAlexander, who is the Allen County prosecutor. Also contributing will be my right hand. We get her on the phone. She would prefer to remain anonymous right now, and she is at home battling a very deadly disease, so any good wishes you can send to my right hand would be appreciated. Today, we're going to cover and discuss Criminal Rule 4. Not as clinical as it sounds, actually. I found out it is unique to Indiana. Criminal Rule 4 does not exist in any other state.
Well, it's just how it's designated.
Okay. And but first, I think we should talk about what's going on in the courts this week. So, Mike, what's going on in the courts this week?
We have a child molesting trial going on. Yesterday, we had a sentencing on a murder case that received a sentence of 80 years with 60 years on the murder and 20 years on the firearm enhancement. Last week, we had 2 murder trials that juries returned verdicts of guilty on. Those will be sentenced in roughly 30 days.
Right. First one was Thristian Boykin, who was accused and convicted of shooting 48-year-old Byron Keith Curry on March 7th, right in the middle of the afternoon. And then we also had Friday another conviction for DeAndre Jones, who with Travell Crum, who's already been sentenced, accused of trapping Javion Granberry as he drove into the Shell station on Tillman Road on Christmas Eve 2023. He will be sentenced on April 28th. So I have written up both of those murder cases along with some other stuff, and we will be getting up the website probably today, and you can see what I saw in court, because I do like to do that. So now, can we get my right hand on the phone, please? All right, okay, so Criminal Rule 4 determines when an offender must be released from jail, even if the case hasn't gone to trial. It's been around since the 70s and has been amended. But one of the things that I want to point out is that sometimes people who've been charged with heinous crimes are released from jail. And people say, why are these people getting out? How dare they do that? Well, chances are in Indiana, it has to do with Criminal Rule 4. So, Mike, tell us, what is Criminal Rule 4?
It's probably more commonly referred to as a speedy trial right, but it also provides time limits for when the state has to bring somebody to trial. An individual defendant can request, probably the most common one is the 70-day trial rule, where they request from the court that they be tried within 70 days. There's also a provision that if somebody is held in custody, they should be tried within 180 days.
All right, that's what I've read.
And then the third part of the rule is that you should be tried within 1 year, regardless of whether you're in custody or out of custody or a combination thereof. However, that time is told when a defendant requests a continuance. The state can't really contest that, other than for good cause shown. If we show that we have evidence that is unavailable or witnesses unavailable, we can get a 90-day continuance to produce that evidence or those witnesses. Most commonly, what you hear about when you hear about Criminal Rule 4 or the Speedy Trial Rule, this comes from the U.S. Constitution, which does not have a strict number of days attached to it. But in Indiana, they decided to make that those 70 days, 180, and 1 year restrictions to kind of define what is a reasonable amount of time.
Can I ask you, did the federal government ask the states to set these guidelines?
Well, it's in the U.S. Constitution. So right. In order to comply with the Constitution, each state developed their own kind of definitions.
So was there a problem leading up to the 70s? Like, were people being held like forever?
I don't know that that was the case so much, but I think it was because it was enshrined in the Constitution. They wanted to move them forward. Actually, when you look back historically to a lot of famous crimes, they were tried very quickly. From the time of the event till the time of decision, till the time in cases where the death penalty was at issue, when the execution was carried out. So the bigger problem that we have with it is on the end of getting cases prepared, because the remedy, if you don't meet the 70-day rule, is dismissal of the charges. Mm-hmm. If you don't meet the 1 year rule, it's dismissal of the charges. If you don't meet the 180-day rule, then you can be released from custody.
Okay, so when you say dismissal of charges, they can be brought again, from what I understand.
No.
Oh, they're not? Okay.
No, it's with prejudice.
Aha.
So that's why it's very important for us to move forward on those.
So I have from my notes here that the defense can continue the trial, mm-hmm. but not the prosecution. Court and the other reasons that a trial can be continued without this kind of problem arising is court congestion or an emergency situation. Mm-hmm. So we know we have court congestion here in Allen County.
Yes.
Okay. And then can you tell us a little bit about what would be a likely emergency situation that could?
Well, we just lived through one a few years ago called COVID, where our courts were closed for, from
Good
doing
point.
trials for a total of about 9 months in 2020 and 2021. And the Supreme Court issued orders of emergency to stay all proceedings during those times other than initial hearings, but no jury trials were conducted.
So was that the state Supreme Court, Indiana Supreme
Yes,
Court?
state Supreme Court.
Just wanted to make sure.
Other ones could be matters of your community gets a snowstorm, a blizzard type of thing, and so people can't get to work. The courthouse burns down. I mean, there's a variety of things that could create an emergency.
Well, when the state has to continue, what could be some of the reasons? Like when I was driving here today thinking about it, I thought, well, maybe a witness bailed out.
I tell you, we have had, over the years, I have seen so many different reasons. Sometimes a necessary witness doesn't show up and we can't go forward without their testimony.
I have an example.
We know you do.
I mean, we have somebody get sick.
We're getting to that
Prosecutor gets sick, defense lawyer gets sick. I had a trial once where they walked in ready to go for a two-week trial, and the defense lawyer was sitting in pain trying to pass kidney stones.
Oh my gosh.
And
so why the heck did he even show up?
People have had family members get sick where they had to leave town. A variety of things can happen. We also, run out of jurors sometimes. We don't have enough jurors.
Really?
During COVID, or right after when we started back up, we had a couple of instances where we had to continue the trial because we didn't have enough. Technically, those may be considered a mistrial, but you're taking a lot of moving parts between the defense, the prosecution, the court. What if the judge gets sick? What if, you just have so many different things that can go wrong when you're trying to bring all of these people together. So,
and yet I think it's kind of rare here that this happens.
We've had things stop at the last minute, but frequently we have more than one case ready to go at the same time. I think last week I mentioned the number of murder cases we have, but that we used to average filing 10 a year, and now we're filing the last 5 years an average of 32 a year. But like last week, we had actually 4 murder cases set to go, and so we tried 2 of them, and 2 of them were continued on court congestion, and among other cases that were continued on court congestion. So a lot of cases do move on. That creates that, but the criminal rule 4 cases on the time concerns are the biggest danger and the ones we worry about the most because of the potential for a discharge. Now, there are interpretations of it that a defendant can't let this happen by accident. If a trial date is set and he doesn't affirmatively object to it as a violation of his criminal rule 4 rights, he may not get the discharge.
That's up to the judge.
That is up to the judge and case law.
So can you explain that a little bit more?
The Indiana Supreme Court just did a case recently where the court determined, I think it was 8 days before the trial, that the defendant had competency issues. So they ordered him to be evaluated. They then got word months later that he was competent to stand trial. Well, they set it for trial within 70 days. The Court of Appeals determined that that was a violation of the defendant's rights because they should have just treated that as it told, and he should have been brought to trial within 8 days. The Indiana Supreme Court took review of that case and made the determination that because the defendant didn't object to the new trial date, it was within that realm. But they upheld the Court of Appeals decision to say that it didn't, it just told the statute, it didn't give a new time period to go on.
It sounds complicated.
It is.
Who is
it's very confusing.
Who is the timekeeper here at the Allen County Prosecutor's Office?
Well, each lawyer on a case is held responsible for that. We've also assigned one of our deputies to kind of keep track of that independently, to kind of act as a system, a tickler kind of thing to remind people that these things can be complicated. And there's all sorts of rules that also hit it if somebody is in custody in another county and they send us a letter saying they want to be brought in front of it. When does the clock start? So there's a lot of litigation around this.
So in other words, they might have to take care of one case in the county before you can get the trial started here.
Yes. And that gets very confusing for everybody when you've got people facing charges in multiple counties.
Oh, jeez.
So the other thing about Criminal Rule 4, particularly the 70-day rule, that was put in at a time when cases were brought to the prosecutor, a written report, and whether it was 10 pages long or 1,000 pages long. It might
the probable cause you're talking about?
No, this is police reports.
Right. Okay, but isn't that a probable cause?
No, it's a police report. From the police reports, you create the probable cause affidavit to file the case.
All right. Well,
but you could go through that and read through it, figure out who your witnesses are, outline your case, and it was probably realistic to be ready for trial in 70 days. Now we have so much outside evidence that has to come in, whether it's cell phone records, DNA analysis, drug analysis,
firearms
forensics, cell phone location, all sorts of things like that, and we rely on outside instruments, whether it's to Instagram or X or other places like that.
And you keep the Indiana State Police, their forensic labs, very busy.
Yes.
Because we have so many homicides.
70 days is, in my view, a little unrealistic in our modern age to be able to bring a case to trial and be fair to both sides, to make sure that all the potential evidence, both that favors the state and favors the defendant, is available.
Well, I noticed in the Friday conviction here, there weren't any text messages in that trial, but there were street cameras. You had visuals from inside the 19th hole, and then you had visuals from the street at Hannah and Tillman. So, the Explorer and the other car. So, yeah, I mean, somebody has to sit there and go through that footage.
Right, and that also gets into when we interview witnesses and potential defendants. All of that stuff has to be reviewed, and it is now when somebody comes in, it's not doing a little 10-minute interview, write up the report, and discover it to the other side. You may have somebody sitting in an interview room for 2 or 3 hours, even though the actual interview time, if they're doing kind of a shuttle diplomacy, may only last for a half hour out of that time, but you have to watch all of it to see what happened.
Well, one of the things that the state Supreme Court, the Chief Justice Loretta Rush said in her January address was that AI is going to become more and more important. And I think maybe that will help.
And that's one of the things we're looking at. Right now in jail calls, for example, they are being run through to get transcripts with AI.
But you can't use them as evidence. I've heard all the judges say, this is not, what do they say?
It's an aid.
Right.
A transcript is an aid to the jury in understanding what was done.
But in other words, how could that not be evidence? I mean, if I were sitting there, and sometimes those phone calls, you can barely understand what they're saying. You really need that piece of paper. So,
well, that would be up to the court then to determine if the transcript is accurate enough to serve as an aid to.
Right. It's like
but the actual evidence is they're listening to the jail call.
Right. I agree. But it's like if you speak another language, and then, let's say you see something in French, and you see it translated into English, and you're like, who came up with this?
Well,
Or Spanish too. I mean, I guess anything. Those are my 2 languages. And I just think, I don't know. I mean, I guess somebody would have to check it. But lots of times as a reporter sitting in the courtroom, I wish I could get a hold of those transcripts. Please let me see them too, because sometimes they're, you hear a little bit here, a little bit there, and I was like, okay, what can I use that in my story? Because it's gripping sometimes what they say. Mm-hmm. So I just want to say before my right hand gets going, she does have a very good case that is going to, we're going to sort of like look all this over. I covered a case in Kosciuszko County last summer. It was the boating accident in Wawasee. It took place in August of 2020. The man wasn't charged until November of 21. So from the time that the boat accident actually happened to the time that it was adjudicated, it was almost 4 years. Sometimes memories are a little bit fuzzy on things and everything else. But what he did and what he was allowed to do because of this criminal rule 4 was continue that trial. And the judge had to go along with it. But there were numerous continuances. And so that's where I wondered and wish I'd known about criminal rule 4.
Well, generally, the court is more lenient. You still have to justify a good reason for when you ask for a continuance, whether you're the state or the defendant. But it's probably a little wider latitude in general for the defense than it is for the state. Right.
He did a lot of subpoenas. So anyway, my right hand, what you got today?
Well, can I say the name of the defendant?
Is it a closed case or an open case?
Both.
Well, I can't discuss open cases.
But we can.
It's an example of how the state. I just won't say the name, but in this particular defendant's case, he's committed 2 murders. The first
allegedly
murder he committed.
I'll say allegedly.
Allegedly, correct. He's allegedly committed 2 murders. And the first homicide that he's accused of, there was a case filed, and right like the week before the trial was supposed to start, the key witness was accidentally hit by a train, and so the state had to request. Instead of requesting a continuance and violating CR4, they dismissed the charges without prejudice. Without prejudice, right? That means they can file again?
Yes.
So the state dismissed the charges because their key witness
was
accidentally got hit by a train. And so they eventually collected more evidence and filed new charges. But when that case was getting ready to go to trial, I'm not sure what exactly the reason was, because it's not in my case and I wasn't in the courtroom. But the state requested a continuance. I don't know if they didn't realize that the first case, the time that he was in jail counted towards the second case, or if they did know that and just needed a continuance anyway. But they requested a continuance, and that violated the CR4 time. So he was released pending trial. And while he was released, he committed another homicide.
Allegedly.
So, he allegedly committed another homicide. So now he's got 2 pending homicide trials. He, fortunately, for the community, I would say, he did violate the terms of his release. So the judge did issue a warrant, and now he is back in custody. But that is, I think that case in general, or both of those cases in general, are a good example of the CR4 time and how it's used.
Well, the first alleged murder took place on January 6th of 2020. That's the one that was dismissed without prejudice.
Right.
Okay. And it looks as though, I'm looking at my case right now, it looks as though his trial is this the one that's in April?
the most recent homicide that he's accused of, the trial is in April. The first one actually went to trial earlier this year and got a hung jury, and so now it's rescheduled in August.
So I'm looking at that, if I can find that. I was looking at this last night. So I think one of the points here is that if both of these murders are true, somebody who probably shouldn't have been out of jail was released.
Well, and he committed another homicide while he was released. But in my opinion, like the CR4 time, like I said, apparently the time that he was in jail from the first filing that this state ended up dismissing, so they wouldn't violate the CR4 time, counted toward the second filing, which I don't see where that's mentioned in the state code.
Well, let's ask Mike, is that possible?
Yeah, if you're charged with the same crime, same day, same crime, same victim, and we find ourselves in that situation that for whatever reason we need to dismiss the case, the CR4 time that is done on the first filing would be applicable in the second filing.
My case can get mighty confusing.
I assume that that's what happened. Like I said, it doesn't spell it out in my case, and I wasn't in the courtroom, but that's how it's been explained to me by the prosecutor's office, people I know in the prosecutor's office. That's what they explained to me.
Yes.
Happened was that the CR4 time from the first filing counted towards the second filing, and they needed a continuance. So when they requested that continuance, that violated the total CR4 time, and so that's why he was released.
And so,
until the trial.
how do you think it fit into the CR4? What was the reason that you?
Well,
think
I believe was stated without getting, I think, oops, take that out. Sorry. Was the fact that a key witness was eliminated. They later developed new evidence or additional evidence that made us feel that we had enough to go forward and enough probable cause to go forward for a new trial. But because it was same victim, same case, the CR4 time from the first charge applied on the second charge.
Well, wait a minute. You're saying the same victim.
Mm-hmm.
Oh, I see. For the first choice, yes. The person who was allegedly murdered is still the same person.
Mm-hmm.
Okay. It doesn't take Sherlock Holmes to figure that one out.
Right.
Okay. And then in the second one, very sadly, that one will take place. That one's in April, my right hand, and then the other one is in July, right? Do I have that right?
Correct.
No, and that's the concern we have. Clearly on any kind of a murder case, that is why in general, the Criminal Rule 26 regarding bail allows us to keep murderers in jail without bail. But every person that we release, whether it's under CR4 or whether it's a simple cash bond or something, or release on their own recognizance, the concern is always for the public safety. And it could be a misdemeanor OWI, and the person goes out and gets drunk again and kills somebody. Sadly, we've had those happen.
Really?
Most situations, if you can think of it, it's happened. But that's always the concern. As we talked last week about domestic violence cases, everybody's big nightmare is you release somebody on a domestic violence case and they're going to go find their victim and finish the job. So this is something
what can you do in that case? You know, that if you are terrified, the prosecutor can slap on a no contact order, as far as I know. Or wait a minute, you recommend the judge.
We ask the court for
right.
it.
But are there any other things that could? I mean, I know this is veering off a little bit from Criminal Rule 4, but What are some of the safeguards?
Well, you mentioned one of them, but as they say, a piece of paper, it doesn't stop somebody who wants to kill somebody. And there are some practical aspects. We do our best to evaluate the risk factors, but sometimes the law provides rights to defendants that we have to respect. That's part of our system. And we take those risks, but we hope they don't happen. But unfortunately, they do.
The judge has no discretion in those kind of
That's right.
situations, especially CR4, right? Like the judge can't say, well, you're too much of a risk, so I can't let you out even though the CR4 time's been violated.
That is true. And our hands are tied, but that's part of the system that our Constitution has given us. I certainly don't always like the results. And I think there's, as I was saying earlier, I think some of these rules need to be modified to reflect the changing technology that we have, both from the standpoint of how long it takes us to prepare a case these days compared to what we could do 20, 30, 40 years ago. But I also believe that there ought to be something there that if we determine somebody is a danger, is there some way to monitor them with electronic monitoring or something that could enable us to have greater controls than what are traditionally used right now?
So if you were to hope that you could put electronic monitoring on somebody that you're really afraid they're going to go out and hurt somebody, would that have to be done first by the legislature?
Yeah, I was going to ask, Mike, how do you go about getting that changed?
Well, I think we can do some of that under special circumstances, but generally we're limited once they've exhausted their CR4 time as to how far we can go. I think it would take a legislative act or an amendment to the criminal rules, and sometimes they do both. Like Criminal Rule 26 is in our Constitution, essentially. It's in legislation and it's in a court rule. So some of that, and there would probably have to be standards involved that would better outline who would be eligible, so it doesn't become too not consistent, I guess is the way to put it.
See, this is like a law class, which brings me to another point. Yeah, go ahead.
We'd have to get some state legislators on board to even hope to get a change to CR4.
Well,
They've amended it before.
CR4 is a rule of the court, and the Supreme Court has a rules committee that reviews this. They actually did a fairly significant review of Criminal Rule 4 and some of the other criminal trial rules that took effect January 1 of 24.
I saw that.
They tried to, I think, clean it up a little bit, make it follow the current case law a little better, a little more understandable.
Do you feel like it was
difficult.
kind of weighted toward the prosecution, or was it kind of weighted toward the defendant?
Well,
or do you want to say?
I probably feel like it gives a lot of rights to the defendant. As I said earlier, when we're talking about a specific number of days, the U.S. Constitution doesn't do that.
Right.
And what was a reasonable time 250 years ago may be a lot different than what's a reasonable time now. And I think it's those kind of things that we should keep up with. I know I've personally kind of asked our Association of Prosecuting Attorneys to speak with the court at the Supreme Court level about modifying some of these things. So I think
Are you on a committee?
I'm on the Prosecuting Attorneys Legislative Committee.
Okay. Because there is something called the National Center for State Courts, and that gives guidelines for how long felony cases should take says 180 days for felony cases, but the American Bar Association, now this was about a decade ago, said they should all be disposed of within 120 days of an arrest or if a charge is filed. And the longest timeline should be 365.
Well,
In our research, Jamie, though, we found that no other states give specific numbers that we could find, like Indiana does.
Well, wait a minute. I do
In
have
their-
some.
the federal
in their
government,
state code.
yeah, the federal government doesn't even have a mandatory specific number of days.
We were having a tough time finding something.
So, these are things that have been interpreted over many years, and each state has their own kind of practice. The American Bar Association does not always adequately represent, in my view, the role of prosecutors.
That's
And
interesting.
and even their rule on that, to say that every case should be resolved in that matter of time is probably unrealistic, and a lot of that would come from the defense. And most of the motions for continuance come from the defense, not from the state.
Right, because you don't want to run into the problem.
Right.
So it's like a chessboard.
Go
We
ahead.
actually talked to a defense attorney that said he felt like those time constraints were adequate.
Yes,
I
I
think most
talked to
defense
one.
attorneys would say that.
He said sometimes you can't get stuff prepared for trial that quickly. I call it equalization and fairness of a game. So yeah, you've got people on the defense side too that says it's not enough time.
No, and you get into issues like on drug testing as an example of our state ISP drug labs are really backed up. And it's something they're always encouraging us, if we resolve a case beforehand, to make sure we let them know so they don't waste time analyzing drugs that the case has already been resolved.
Right, there's a lot of moving parts in all of this. And what it comes down to is you want to adjudicate in the best timeline, on the best timeline that you can. So,
All right. Well, I think
want
we
to have
go ahead.
adequate evidence. You need the prosecutors want to have adequate evidence, and they just have to be mindful of the CR4 time. And like the example case we talked about in the first filing, dismiss the charges if they have to, rather than violate the CR4 time, or assess the risk. Which is. I mean, I guess it doesn't matter. In either case, if they dismiss the charges, the person's getting out into the community, and if they violate the CR4 time, the person's getting out into the community.
Right, and in this way, though, if we lose key evidence and then we're able to find additional evidence, we can refile the case. But if we just let the CR4 go and they're discharged, we can't bring that case back again. It's like getting a finding of not guilty. We can't prosecute them again for the same crime.
So the prosecutors just have to be mindful and dismiss the charges if they don't have everything, and then refile when they have everything.
Yep.
and who is it? The one that is it? The judge that says, "Okay, you haven't done it. This guy's got to go."
Generally, the responsibility to request this comes from the defendant, needs to move for discharge.
So if they don't move right away, what kind of time frame is that? If they don't move right away, can they, 30, 60, 90 days later make that filing, or
That is,
is there a time limit?
that has happened, but what they run into, and that was the recent case where they need to notify the court and the other side as soon as possible as they're aware that there's been a violation. So that's to prevent somebody on a congested calendar sitting there quietly and accepting a trial date that's 3 months out when their CR4 time it only has 2 weeks left.
Oh,
And that's how the court kind of worked around that situation where they only had 8 days left. And they set it within the 70 days, thinking that they could start a new time limit. And they
start the clock again.
Yeah, and the court said they were wrong on that, but the defense couldn't just sit back and wait till the day passed and then jump up and say, ha.
Well, have you ever just taken one and said, all right, it's going to be a crapshoot, but we're just going to do it anyway so that we don't have to release this individual?
That's
We don't feel really well prepared, but we're going to give it a go?
Well, that is always the case. And particularly, and this gets into a whole nother topic that he knows about. Sorry again. But that has to do with, and
Just say it again.
Yeah, we've touched on double jeopardy, where you only get one bite of the apple. You bring charges, you take that case to trial. If you lose it, you're done. You can't bring that back again. And particularly on murder cases where there's no statute of limitations, there are times where we're reluctant to file because we don't think our case is strong enough. And we're waiting for that little bit that would push it over the edge. And a lot of times that might be somebody who's in jail for something else, and they have loose lips and they talk to somebody they shouldn't, who notifies that this guy told me how he did this killing. And if we can then use that as evidence and back up the evidence we already have, then we could bring charges and go forward. So it's why, especially on a case like murder, where there is no statute of limitations, we're reluctant to go forward if we don't feel we have enough to get a conviction. And we have an ethical responsibility to the defendant not to go forward unless we feel like we have a conviction. Now, on the other hand, if we're on a burglary case that has a 5-year statute of limitations, and we're 4.5 years in, and there's no real expectation that we're going to get anything else, then maybe we would file that and take a chance on it if we thought we had it, but recognizing that, you know, we may not have the so-called smoking gun for the case.
Interesting. So
one of the things at first, when my son first was killed, that just I thought just was such crap. Like, oh yeah, sure, you wait a couple years and you're going to get more evidence. And as time has gone on, I've really changed my point of view on that, because I've seen where exactly what Mike said happened. The guy got to talking in the jail, and that person came forward and was willing to testify, and so they were able to file charges and have a good case and get a conviction. So my perspective on that has really changed over time. And I talk to all of our families, often families that are waiting and frustrated because charges aren't being filed. And I can give them examples of where different pieces of evidence have come over time, and they were able to file and get a conviction. So that definitely happens, and it was something that I didn't believe at first, but now I've seen it happen, so I'm forced to believe it, I guess. But I wanted to talk about one other thing that I've seen happen, is where the defendant asks for a speedy, and then when it gets close to time for the trial, the defense requests a continuance. Can they still then ask for another speedy when that happens, or does that speedy request go out the door?
Generally, it goes out the door at that point.
Okay.
Now,
that's something I was wondering. Like,
yeah.
Can that speedy request be carried through if the defense requests a continuance?
Yeah.
On a speedy.
Yeah, generally not once they waive it in that situation. However, if they go to trial, they get a mistrial, they can then renew another request for a speedy at that point.
Okay.
it's like a chessboard. That's what it reminds me of.
And I can tell you, the rules, they are hard to keep up with. The case law becomes very nuanced on the specific facts of each case and how notices were given. It is very convoluted, which again is why I would, just as soon as we got rid of the 70-day rule and just went with the 180-day rule, which in most cases would give us enough time to gather all the evidence, and it would get us out of some of these kind of gotcha moments.
Except for I have seen early trials delayed due to court congestion. That's definitely the ace in the hole around here.
Well, generally, they put the speedy trials at the head of the line.
Right.
They're occasionally...
When there's two speedies on the same docket, they've
Yeah.
got to continue one of them.
Right.
And occasionally, for really good cause shown, they can congest a speedy, not necessarily with another speedy, but usually if you got two speedies, one of them is going to go.
And a speedy is supposedly 70 days.
Yes.
As opposed to 180 for those people who are trying to keep all this straight.
Well, and we're in that situation right now that we've hit situations at various times when the court does not have any time available within that 70 days to do a trial. Oh. And so it's incumbent upon the state and the court to make a good record establishing that this was the first available date on the court's calendar and that the defendant accepted. What the state wants doesn't really matter in that situation. So if we have attorneys that are assigned to other cases or cases on that week, we're held to the standard that, well, then you're going to have to reassign your cases within your office. That's also frustrating.
So what happens if the court's docket is full at the time, but then other cases get continued and there actually ends up being openings during that 70 days? Does that matter? Or does it just matter what is on that day that you're setting that trial date?
Generally, but I say this very generally, and that's one of my particular nightmares, is can that situation come up? I have not seen that happen. It also gets into the question, okay, you're setting this trial, you ask for a speedy, and next week is open, but then there's nothing open from then for the next 70, 80 days. So you're setting it out 90 to 120 days. What is the argument, and particularly on the practicality of, to either side saying, well, we don't have anything open till after that unless you want to go this Tuesday.
And that wouldn't give you enough time.
And that would not be fair to witnesses, victims. Logistically, I don't know that we could pull it together on a major case like that. But certainly that is one of the concerns because every scenario is not covered by the rule.
Right.
Interesting.
Right. And it apparently hasn't been tested in the appeals court up to now. So
Yeah.
Ultimately, it would have to be tested in the appeals court to know what the answer is.
Right, and that's always concerns us because if you get the wrong answer, you get a result that we don't really like and could be very detrimental to the families of victims, and that's the last thing we want.
So, I think this has been a great discussion on Criminal Rule 4 and why people get out of jail when you're not really expecting it. Is there anything else that anybody wants?
Informative.
It was, yes. I do want to remind people that this podcast will be posted on the Probable Cause Facebook page and on YouTube. We are working on Instagram and TikTok too. But I think most people have Facebook and most people have YouTube, so I think we're covered there. So until next time, this has been The Probable Cause. I'm your host, Jamie Duffy, co-host Michael McAlexander, the Allen County Prosecutor, and my right hand, who at this point is still anonymous. Until next time, goodbye. This episode is filmed and edited by Frosty Pictures. The Probable Cause is produced by Maumee Media.